An appeals court has just upheld the $83 million defamation judgment E. Jean Carroll won against President Trump. Let's go live right now to CNN's Kara Scannell. Kara, the president lost the appeal, so what happens now?
Well, if the president did lose this appeal, and he already set aside money in order to pay E. Jean Carroll, but the litigation here is most likely not over. Donald Trump's lawyers releasing a statement in which they said that they will continue to fight this, and that they said the defense will be taken over by the Department of Justice. This was a civil lawsuit that was brought against President Trump when he was out of office. It went to trial when he was out of office, but now he is saying it should be handled by the Justice Department as this moves forward. Now, the next step here would be a challenge to the U.S. Supreme Court. That is certainly something that the Trump administration can attempt to do, and it would be up to the justices to decide whether to hear this. But you'll remember this was the big judgment against Donald Trump.
What's happening, friends? Welcome to Dr. John Podcast right now. The Supreme Court didn't just rule against Trump on the E. Jean Carroll verdict. They refused to even hear the case. No nuance, no diplomatic lifeline, no split dissent, just a cold, silent refusal that leaves the judgment permanently intact and every talking point built around escaping it completely demolished. Now, before the internet fever swamps break out and try to manipulate your algorithm with fabricated theatrics, let me be completely transparent about the mechanics of how this humiliation actually went down.
As he was a candidate brought by E. Jean Carroll, the magazine columnist who said that he had sexually assaulted her in a New York department store in the mid-1990s, and she went on trial twice. The first time, a jury found that Trump had sexually abused her and had defamed her when he denied the assault, when he said that she wasn't his type, and when he said that she made up the claim to boost sales of her book. That jury awarded her $5 million. Then they also had a second lawsuit that went to trial that was just focused on the defamation. And it's that decision, that is this $83.3 million verdict, that the jury had awarded Carroll. Now, in this, the judges here pointing out that even though the big chunk of that $65 million was for punitive damages, that means to punish Trump, the judges saying that they were upholding this even though it was very high compared to a ratio of compensatory damages, because it was so extraordinary and unprecedented, because Trump had continued to repeat the statements that a jury had already found to be defamatory within 48 hours after the verdict at a CNN town hall and then during the trial itself. So that is the basis for which this appellate panel is saying that they are upholding this verdict. Next steps will be to see if the Supreme Court is asked to take up the case, and if they do. Wolf?
If you have seen viral claims swarming around that Trump physically showed up at the marble steps, dropped to his knees in the well of the courtroom, and started sobbing while the justices pointed and howled with laughter, you need to purge that image from your mind, because that is not reality. The Supreme Court does not operate like a reality show reunion special. There were no cameras rolling.
12:09 here on the East Coast. Welcome back to Live Now from Fox. Take a look at your screen. The Associated Press reporting on this Monday, breaking. The appeals court upholding the $83.3 million defamation judgment that E. Jean Carroll won from President Donald Trump. As we are learning about this breaking news, I want to provide more perspective on this story. In a ruling issued this Monday, the Second U.S. Circuit Court of Appeals rejecting President Trump's appeal of the defamation award, finding that the jury's damages awards are fair and reasonable. AP goes on to report that President Trump had argued that he should not have to pay the sum as a result of a Supreme Court decision expanding presidential immunity. His lawyers did ask for a new trial.
There was no live audience gasping. There were no judges mocking him to his face while he begged. The true process is far more sterile and in many ways far more damaging, precisely because it was so impersonal. This was a paper process, a quiet filing of a petition known as a writ of certiorari.
A civil jury in Manhattan issuing the $88.3 million award last year following a trial that centered on Trump's repeated social media attacks against Carroll over her claims that he sexually assaulted her in a Manhattan department store back in 1996. Now, that award followed a separate trial in which Trump was found liable for sexually abusing Carroll in order to pay $5 million. That award was upheld by an appeals court last December. In a memoir and again at a 2023 trial, Carroll described how a chance encounter with Trump at Bergdorf Goodman's Fifth Avenue in 1996 started with the two flirting as they shopped. then ended with a violent encounter, as Carroll says. It happened there in that department store with a violent struggle inside of a dressing room. Carroll saying that the now President Trump slammed her against a dressing room wall, pulled down her tights, and forced himself on her.
It sat in a stack of hundreds of other pleas from convicts and corporations alike. And when the conference met behind sealed doors to decide the fate of his appeal, they simply moved on. They issued a standard denial. No comment, no explanation, no dissenting opinion from the conservative wing. Just a line item on a list that said, "The highest court in the land will not save you." They didn't laugh at him.
A jury did find Trump liable for sexual assault, but concluded he had not committed rape as defined under New York law. President Trump repeatedly denying that the encounter took place and accusing Carroll of making it up to help sell her book. He also said that Carroll was, quote, "not my type." The 2023 jury awarded Carroll $5 million to compensate her for both the alleged attack and statements that Trump made denying that it ever happened. After that first verdict, the court held a second trial with a new jury for the purpose of deciding damages for additional statements Trump made attacking Carroll's character and truthfulness. President Trump has skipped that first civil trial, but he attended the second, which took place as he was running for president in 2024.
They ignored him, which is the most brutal thing a court of kings can do to a man whose entire identity is built on the myth that he never loses. To understand why this financial and reputational atom bomb is so devastating, you have to rewind the tape on the incident that started it all. An encounter that happened in the haze of the mid-1990s, in the cramped, dimly lit confines of a luxury department store dressing room. E. Jean Carroll, a seasoned writer and advice columnist with a sharp wit and a long career.
Speaking to reporters throughout the trial, Trump portrayed the lawsuit as part of a broader effort to smear him and prevent him from regaining the White House. His lawyers did complain, saying that the judge, in setting rules for the second damages trial, had barred Trump and his defense team from claiming in front of the jury that he was innocent of the attack. The judge ruling that the issue had been settled by the first jury and did not need to be revisited. So a lot we are following as it relates to this breaking news this Monday. Again, take a look at your screen as the Associated Press does report that an appeals court did uphold E. John Carroll's $83.3 million defamation judgment against President Donald Trump. Of course, this is a developing story.
Came forward with a harrowing narrative that painted Trump not as a flashy real estate mogul, but as a predator. She described in excruciating detail how a lighthearted chance encounter on the sales floor turned into a nightmare behind a locked door. She alleged that Trump physically overpowered her, slammed her against the wall, and sexually assaulted her with his fingers before she managed to fight her way out and flee. It is a dark, visceral account. When she finally summoned the courage to bring this story into the public square, Trump responded with his characteristic scorched earth playbook. He didn't just deny it. He aimed a fire hose of toxic vitriol directly at her reputation. He called her a liar. He insulted her appearance. He claimed he had never met her, a bizarre assertion given that photographic evidence placed them in the same social orbit. He stripped her of her dignity on the national stage, and that act of defamation became the legal engine that would eventually hit him with the force of a freight train. The judicial system, moving with the slow but inevitable gravity of justice, finally put this dispute in front of a jury of ordinary citizens. In that courtroom, the mask slipped completely. The jury listened to Carroll's testimony, which was bolstered by the accounts of two friends she had confided in immediately after the incident happened. This prompt outcry testimony is gold standard credibility material. They then witnessed the presentation of the Access Hollywood tape, the infamous hot mic recording, where Trump's own voice boomed through the speakers, bragging about how his celebrity status allowed him to grope women without waiting for permission. The defense screamed bloody murder about the tape, arguing it was prejudicial character assassination, but the context was undeniable. It wasn't just that he was a bad guy, it was that his own words described a modus operandi that mapped perfectly onto Carroll's trauma. The jury saw the truth. They deliberated, and they hit him with a verdict that shattered the illusion of his untouchability, liable for sexual abuse and defamation. The price tag for that first round was $5 million. But Trump, suffering from a pathological inability to keep his mouth shut, stepped out of that courtroom and immediately began vomiting the exact same defamatory slurs that had just cost him millions. He torched the verdict, called the whole thing a witch hunt, and branded Carroll a fake. So, the legal system did something it rarely does. It went back for seconds. A second jury convened, looked at his post-verdict behavior as a defiant middle finger to the concept of accountability, and decided to impose a punishment that would actually echo. They returned with an $83 million punitive damages award, creating a combined financial obliteration of $88 million. With that background established, we arrive at the final act of this courtroom drama, where Trump's high-priced legal mercenaries scrambled to find a loose thread to pull. They petitioned the Supreme Court with a very specific argument. They claimed the initial trial had been permanently tainted by the admission of evidence that should have been excluded, focusing primarily on the Access Hollywood recording. Their brief argued that the tape created a tornado of bias that swept away any chance of a fair fight. They posited that the jury was encouraged to convict based on a general sense that he was a lecher, not because of specific evidence relating to that specific dressing room. They hammered the absence of forensic evidence, the lack of a police report, and the missing surveillance footage from an era before cameras were everywhere. Their logic was a classic criminal defense strategy. If there is no physical proof, and if we can blame the verdict on inflamed emotions stirred by a nasty tape, the entire structure of the lawsuit should collapse. They also leaned on the eyewitness issue, suggesting that a he-said-she-said dispute should never result in $88 million in damages. They aggressively pushed for an en banc review of the appeals process, hoping to sway the broader bench, and when that door was slammed with force by the lower appellate courts, the Supreme Court was the final, solitary life raft in a sea of legal sharks. The Supreme Court's decision to deny certiorari is where the political narrative detonates in spectacular fashion. We need to dissect the ideological makeup of the bench to truly savor the irony. This is a conservative supermajority, a 6-3 fortress that has reshaped American law on abortion, guns, and religious liberty. It features 3 justices who owe their black robes directly to Donald Trump: Neil Gorsuch, Brett Kavanaugh, and Amy Coney Barrett. These are not secret liberal saboteurs hiding in the Federalist Society. They are the crown jewels of his judicial legacy. And yet, when the history of the Trump presidency is written, their silence here will scream. They looked at his petition and let it die in the darkness. Not one of them stepped forward to write a dissenting opinion arguing that the court should take the case. Not one of them signaled to the MAGA faithful that there was a grave constitutional injustice that needed correcting. This silent rejection functions as a legal endorsement of the verdict. It tells the entire country and the world that based on the existing record and the established rules of evidence, the lower courts got it right. Trump cannot credibly stand at a podium and scream about weaponized government when the government's most powerful weapon, the judiciary he handcrafted, refuses to pull the trigger for him. If the system was truly rigged by the deep state, how did the riggers manage to hypnotize his own hand-picked judges into stonewalling him? The logic collapses under the slightest weight. We also have to analyze the financial reality of this debt because the aura of the billionaire can often mask a liquidity crisis of epic proportions. For years, Trump has inflated his wealth like a balloon animal, mixing actual hard assets with the ethereal fairy dust of brand value. But brand value does not pay court judgments. Cash does. $88 million is a staggering amount of physical greenbacks to surrender. This sum could have covered rally expenses for multiple election cycles. It could have funded the most aggressive super PAC blitz ever conceived. Instead, it represents a giant hole in his balance sheet that must be filled by selling off assets, liquidating investments, or taking on high-interest loans at a time when banks are running away from him as if he were radioactive. Think about the timing of this financial execution. It lands squarely in a period where his political operation is allegedly gasping for air, running on fumes and begging for small-dollar donations that are drying up. He may be forced to inject massive sums of his own capital just to keep the lights on in his political apparatus. But the Carroll judgment creates a leakage that bleeds that capital into the pockets of a woman he despises. The thought of E. Jean Carroll ultimately driving a car or buying a property paid for by the liquidation of Trump assets is a psychological revenge that no amount of Truth Social ranting can cure. Let us pivot to the broader constellation of his Supreme Court failures because this judicial losing streak has become a prophecy of incompetence. The court didn't just reject him on the Carroll matter. They have been systematically slapping down his attempts to manipulate the law for personal delay. Look at the gag order and sentencing fiasco stemming from the hush money trial in New York. After being convicted on a mountain of felony charges related to silencing an adult film star, he tried to run to the Supreme Court to block his sentencing, arguing that being held accountable would interfere with his presidential duties. The justices issued a ruling that was practically a sarcastic eye roll, noting that the sentence imposed carried virtually no practical restraint on his ability to perform executive functions. They effectively told him to sit down, shut up, and accept the felony conviction. The Mar-a-Lago documents saga, the various immunity claims that sought to erect a force field of absolute invincibility around his actions, the attempts to shield financial records from prosecutors, all of these hit the hard rock of a Supreme Court that, despite its conservative bent, refuses to shred the basic rules of criminal procedure just to save him. This pattern reveals a stark division between the political rhetoric of victimhood and the legal reality of failure. You cannot be the anointed victim of a dark, systemic conspiracy when the system, controlled by your ideological allies, consistently rules against you on the merits. The political messaging implications for the upcoming electoral battles are seismic. The Democratic apparatus now possesses a bulletproof narrative that fits perfectly onto a bumper sticker. A jury of his peers found him liable for sexual abuse. That sentence is now finalized by the ultimate stamp of judicial finality. No appeal is pending. No Hail Mary remains. It is a closed case, a historical and legal fact as solid as the marble in the Capitol. The advertising writes itself. How do you look at a suburban swing voter, a woman in a purple district who is tired of the chaos, and defend a candidate who is an adjudicated sexual predator with a Supreme Court validated debt of $88 million? The GOP's attempts to pivot to the economy or foreign policy will be met with relentless counter-programming, reminding voters that the man at the top of the ticket was formally chastised for attacks on women. The Access Hollywood tape, the very thing his lawyers said was too prejudicial to show, will be aired again and again alongside the verdict sheet. This is not just a scandal. It is a cement block tied to the party's ankles in any district that has a college-educated female electorate. Trump's base may have built up antibodies to scandal, treating civil liability as a badge of honor against the elite. But the margins in battleground states are decided by the sliver of people who still believe the president should be a model of civic virtue. For them, this is confirmation that the rot is real. The culmination of the Carroll case is a masterclass in the American adversarial system functioning correctly against a man who has spent a lifetime dodging the bill collectors of karma. Jean Carroll's victory is not just a personal vindication, it is a historical landmark. She faced the total weight of the conservative media machine, the threats from the online mob, and the psychological warfare of being called a liar by the sitting president about the most traumatic moment of her life. She didn't crack. She proved that the old rules still apply. When a jury looks a powerful man in the eye and believes a woman he assaulted, money can't always make that disappear. The lack of physical evidence, the time delay, the absence of a police report, the defense threw every classic victim-blaming cliche at her, and the jury saw past the smoke. The Supreme Court's rejection validates the jury's common sense. It recognizes that assaults happen in the shadows. Power is often used to silence, and silence is not consent. This ruling provides a template for future survivors that even the most powerful man in the country can be forced to pay for his actions, even if it takes 3 decades to catch up with him. The attempt by some factions to project a fantasy of familial resistance or rupture to this legal setback is a desperate subplot that deserves exposure. There is a whimsical narrative floating around the fringes of political commentary, suggesting that some members of Trump's inner circle, perhaps even his youngest, are secretly mortified by having a sexually abusive, adjudicated father. The fantasy claims that there is a silent rebellion, a quiet slipping away from the tarnished name. Yet, reality continues to pulverize this daydream. Every public appearance, every family portrait staged in the gallery of the State of the Union betrays a unified front. The matriarch has gone on the record with conversations that describe the youngest son not as an alienated refugee, but as a politically engaged young adult who discusses current events with his father. The idea that he is hiding in shame in a dormitory is fan fiction written by people who crave a happy ending, where the family abandons the patriarch. The cold, hard fact is that the entire dynasty remains unbothered by the legal designation. They treat the Carroll verdict as merely another line line item on the expense report of doing political business. The family solidarity is the armor that deflects the shame that would have toppled any normal political operation in the previous century. Let's trace the trajectory of what this debt actually means for the machinery of his political movement. A campaign relies on momentum, advertising saturation, and ground game. $88 million is a super PAC on life support. It is the salary for thousands of canvassers. It is the air cover on television stations in Pennsylvania and Michigan. By draining resources to satisfy this judgment, Trump is effectively taxing his own political revolution to pay for the crime he committed in a department store. Donors who are being squeezed to fund the Legal Defense Fund might be less enthusiastic if they realize their $1,000 donations are simply passing through the Trump coffers straight into a trust for E. Jean Carroll. Every rally where he rails against the rigged system is costing money he no longer has, and the attendees who buy the MAGA hats might wonder if the price of the hat is going toward a defamation payout. The financial stress fractures are starting to show in the overall operation. Vendors are going unpaid, rallies are being canceled, and the constant panic in fundraising emails reveals a desperation that the $88 million millstone only accelerates. The contrast between the man's projected persona and his legal reality has never been more stark. He markets himself as the ultimate winner, a ferocious counterpuncher who never, ever concedes defeat, who writes the book on the art of the deal and leaves his opponents ruined. Yet, in the most intimate and damning legal battle of his life, he has been completely spanked at every single level. District court, loss. Appeals court, loss. En banc request, denied. Supreme Court petition, denied. He has exhausted every avenue of appeal, and the final result is that he is a legally designated sexual predator with an excessive debt. That is the opposite of winning. That is catastrophic, multi-generational failure. The image of the invincible mogul crumbles when the sheriff could theoretically start executing the seizure of assets to satisfy a women's justice claim. All the Secret Service protection in the world can't hide the fact that, on paper, in the cold black and white of the federal court docket, he is a loser. The bully who spent years calling people dogs and criminals is now branded as a deviant by the immutable record of the law. This also exposes the cynical nature of the Supreme Court attack line. For months, Donald Trump has marketed himself as the only barrier standing between his followers and the lawfare of the deep state. He scapegoats prosecutors, judges, and the FBI. But the Supreme Court is the ultimate exoneration or condemnation machine. If they had seen even a shred of merit, they would have taken the case. By refusing, they effectively certified the fairness of the trial. They said that the evidentiary rulings were sound enough to stand. They said that inflating the judgment to $83 million for continued defamation fit the punitive standards of the law. If the deep state was truly manufacturing evidence to destroy him, a conservative justice dedicated to due process would have screamed from the mountaintop. That silence is agreement. It is the most effective political counter-message the Democrats never had to write themselves. The Supreme Court did it for them. What makes it even more brutal is how it intersects with the public's growing exhaustion with chaos. The Iran policy disasters, the inflation anxieties, the daily psychological warfare of social media. And in the middle of it, another final nail in the coffin of Trump's character. The American swing voter is tired. Data shows that people tend to tune out repetitive scandal. But sexual abuse is a different category of offense than hanky-panky with business records. It is visceral. The Carroll verdict, now being set in stone, means that every time a Democrat talks about fighting for women, they have the perfect contrast. They don't even need to mention his policies. They can just let the court records speak. The psychological impact on undecided women, particularly those who might have personal histories that remain private, is massive. Going into a booth to vote for a man who jammed his fingers into a woman against her will is a binary choice that overrides gas prices. If just a small percentage of Republican-leaning women stay home or skip the top of the ticket, the entire electoral map shifts. And where do we go from here? The legal path is terminated. The only option left for paying the piper involves financial acrobatics, likely appealing for payment bonds, trying to negotiate settlements behind the scenes to reduce the payout, or potentially facing the embarrassment of asset liens. Every maneuver will leak. Every attempt to get out of paying will look like a deadbeat billionaire squirming away from a victim. Carroll's lawyers will hound him mercilessly, and they hold all the cards now. In the court of public opinion, this is the eternal scarlet letter. It won't wash off with a new campaign campaign slogan. This case has traveled from a midtown department store in the 90s, through the Golden Escalator in 2015, through the Access Hollywood tape, through a defamation spree, straight into the marble steps of the Supreme Court, and it ended not with a triumphant roar, but with an administrative no. That's the punctuation on the career of the man who claimed he could shoot someone and not lose voters. He didn't need to shoot anyone. He just needed to be held accountable for an assault, and the gavel finally fell. The court has spoken, and for the first time in a long time, he has no words left to spin it. He just has to pay. And in that financial transaction, E. Jean Carroll gets the last laugh, not the justices, but the woman who refused to shut up no matter how much money was spent to silence her.